all rise.
I appreciate that you agreed between you that you would share this afternoon's time for an opening. I'm not remotely surprised that the claimant has to take a little bit longer than might otherwise be expected, because you're having to show me some of the documents. So the position is that we've used an hour and a half and a bit more because of our break. There is a slight limit to my absorption powers, but I will do my best to see if I can see you out. If I fall asleep, you just have to wait until the morning and try and resume then. So shall we see how we get on? Shall we take stock at in about half an hour or so? Is that right?
Yes, I'll hope to be getting within sight of you by then anyway.
Right. Okay.
Thank you. So we've got to February 2015.
Yeah.
Beginning of February. At tab 188 of the bundle, there's the EC Harris report for January comes out. Yeah. And if you go to 2462, you can see the executive summary. And general, they've noted the clause 63 certificate that's been given by the engineer. They say terminating is not a step to be taken lightly, normally recommended to be avoided where possible. Appreciate that there are many historical issues associated with the project, but there has been a report that the contractor has started to procure previously withheld any there's a termination, and they recommend commercial settlement with the existing contractor to be further pursued. And then they note that the owners not intending to extend the services or ill. The programme and progress, the rate of progress remained unacceptable to the project managers throughout January, but there were indications of improvement towards the end of the month. Contractor retracting its previous statement and refused to procure any items.
I'm sorry, I forgot what MEP items are.
It's mechanical, electrical, and I think it's plumbing, but that sounds a little bit untechnical, but I'll check that. But certainly mechanical and electrical.
Yes, okay.
So, I mean, it's always a very large element of any project such as this.
Yeah.
We just note the projected completion date. Now, the project manager anticipated project completion date within the master programme, now 12th of November. However, there is a risk that this will continue to slip.
Yeah.
So that was the report for January. These EC Harris reports continue, and the date continues to slip. I'm not going to show you any more. They're in the bundle, and they can be referenced in closing submissions so far as they're relevant. But it gets repetitive, and the situation is that the date just gets worse and worse as we go on. But we've already got a projection of November 2015. Actual date was March. If it helps, I'll give you the references as we go through.
Well, I leave it to you. It might help in the long run, but I certainly don't want to take up time and cross-reference it too much.
Okay. Then I think there is a significant meeting on the 23rd of February, which we can see a document that relates to it in Bundle 12. We may go on to Bundle 12 now. And to tab 194. And there's a covering email and then a note of a meeting.
Hang on.
Sorry.
194, yes.
194, page
yeah.
2558.
Yep.
We've got an email from Ms. Schrocker who's one of the witnesses, to Mr. Socken, who's another of the witnesses,
Yes.
about this. And it's also, although it says dear Sama, who's another gentleman who's also giving evidence, but it says, in line with the attached approval on the 2nd of March, we're seeking legal concurrence to disburse the pending project payments totalling 11.9 million dirhams. This disbursement was approved by Head Office Level 2 to avoid further legal implications, given that they represent payments approved by the project owner, certified by the engineer and confirmed by the monitoring surveyor for work already done on the site. And this is the approval of the last disbursement that's made on the project. Gets dispersed on the 8th of March in the end. And over the page, you've got a summary report. This was the report to HO Level 2. Shocker seems to have been sending it to Sama, who's the in-house lawyer seeking legal concurrence with it. And 2559 is the Level 2 approval. It's in similar form to previous reports we've seen. You can still see that security coverage of 194%. Under technical issues, you can see the work programme submitted by main contractor sets completion at 26th of August. That's excluding testing and commissioning from March at the time of the restructure. And then commercial issues are recorded. Over the page, we get the reference to the 23rd of February meeting, and what happens at this meeting is controversial. The note says we met with Mr. Musabe Al-Mahiri in the presence of...
So where are you reading on?
I'm in the middle of the page 2560. I apologise, I didn't...
Where are you?
The page 2560?
Yeah, I have that.
Yes, middle of the page, the paragraph beginning on 2302.15.
Oh yes, I have that now, yeah.
So we met Mr. Al-Mahiri in the presence of Mr. Sama Abdul Haq, GGC General Counsel. Client insisted that Intermass and Hill must be replaced to complete the project. He stated that the Department of Planning and Development, Traquees, has suspended Intermass's licence, rendering them unable to obtain the required permits to complete the work. We asked him to revert back with evidence supporting this statement, as this would be a breach by the contractor. Mr. Sama explained the notice of termination would provoke Intermass to obtain an injunction through the court of first instance and engage in arbitration. The legal proceedings to revoke that and obtain a favourable arbitration would take a long time. This would bring the project to a complete standstill, and admitting a new contractor would be impossible. An amicable resolution was recommended. And then we reiterated that the existing delays and pending subsequent constitute a breach of the restructure agreement, and stressed that loan drawdowns are at a halt until a clear strategy forward is in place. And then there's a reference to the 24th of February letter that I showed you earlier from Traquees. Yeah. Then the recommendation of this paper is that the disbursement be made. Notable that under recommendation and action, the fourth line, it says, while disbursement under the BL, that's building loan, has been postponed to bring client to the table to agree a way forward, we recommend the disbursement of the aforesaid payments totaling 11.9 million to avoid further implications, given they represent payments approved. Yeah. So that's approval of the last disbursement. There's a helpful document at tab 197, which is a list of all of the disbursements that were made by the bank pursuant to the facility, going right back to the beginning. I don't think that's controversial. But that was, there'll be evidence about that meeting as then, I'll just say for the transcript, the EC Harris February report is at 12.205. I won't take you to it. It indicates a 31st of December 2015 finish. I'll take you on to 12201. Which records a synopsis of a discussion between Mr. Sokhan and Mr. Al-Muheri. And we can again see the difference of view now as to termination of the contractor. One, reference to a previous meeting with Mr. Thursby of the bank, stated he'd advised GCE there's no potential reconciliation with Intermas, given their numerous breaches of the construction contract, the expiry of their license, and their intentional sabotage of the DWA site inspection by pouring water into an electric generator's room. Then we explained options to the client as followed. Under termination, client insisted he's unwilling to continue with Intermas and is looking to terminate their contract because of the ongoing historical dispute, delays, and the recent evidence that their license had expired, a fact which they intentionally did not disclose. Sabotage. Bottom of the page, we reiterated our earlier concerns regarding the change of the main contractor at this junction of the project that might entail on site. So the difference of view becoming very clear about Intermas. And 203, tab 203, if we go on to that, we can see there's further disagreement between the parties in relation to Intermas emerges if you go to the bottom of page 2592. The bank issue an invitation to Mr. Al-Muheri, but that's an invitation to attend a meeting with, if you look at the attendees over the page, it's to attend a meeting with the contractor. And Mr. Al-Muheri rejects that invitation. Says in the middle of page 2592, the reasons he's previously explained, and it's obvious, I don't propose to take part in a meeting with the contractor. It's not appropriate for the bank to meet the contractor without the consent of DAS. Then at 206, see that this disagreement over whether to terminate the contractor or not seems to be what leads to the beginning of the lead-up to termination. Now we can see at tab 206 there an email from Group General Counsel Samar Abdel Haq, saying that he's now got clearance from the chairman. We move forward to protect the bank's rights. Change of contractor at this stage is expensive and time-consuming. Concerned parties is necessary to identify the gaps, address them, and move towards completion of the project. But the concern seems to be the change of contractor. It's not focus on a date of the 31st of March or focus on conditions subsequent. It is in relation to the change of contractor. Then there is a letter on the 18th of March from the bank at tab 207.
At this stage, there's no resolution of the dispute between the contractor and...
No, and then...
I know that the contractors were looking, I don't know, for something like 80 million. Mr. Mahari recognised, I think, that something like 50 million may be due, but there was an impasse, is that right?
Yes, there was never a...
So no payment was made?
Well, payments, there were payments.
When I say payment, no payment in a partial discharge of what appeared to be due.
Well,
if I'm wrong, that will need to be pointed out to me in due course.
Yes. There's a distinction between...
The dispute was rumbling, indeed had been rumbling for about a year and a half, hadn't it?
Yes, there's a distinction, though, between payment for the work and the contractor's claims.
Quite.
And so...
Well, there was a drawdown which enabled him to pay some part of the continuing building cost.
Yes.
What was still at issue was whether there were, extensions of time. And
That's right. So it's that's not resolved. And I should have said, as we went past, the offer of the 36 million was a without prejudice offer. So there's without prejudice negotiations going on about it. So it's not right with respect to say, well, there's an acknowledgement that that's due.
That was not enough.
There was an attempt at a commercial settlement.
Thank you.
So if I can then show you the letter of the 18th of March 2015 from the bank, which is at tab 207. And we needn't worry about the first paragraph. Then they note in the second paragraph, they note his declining the invitation to the proposed meeting. They'll cancel it. They say they requested it in an attempt to engage in dialogue to get the development on track. We'd like to take this opportunity to point out that under the restated agreement, the bank has consent rights in relation to the appointment of the contractor and the project manager. We don't accept your position that the bank has no rights with regards to the contractor. If consent rights are not observed, DAS will be in breach of the agreement. We note you recently terminated Hill and without obtaining consent, which is a breach. Factually not quite correct because their appointment expired and was not renewed. Then over the page, they say the construction contract is assigned to the bank under the construction contract assignment, and if this security becomes ineffective for any reason, a further breach will occur. Then they say, as you know, we've committed full support. We have significant concerns over the lack of progress on site. Our understanding is that the development is currently at a standstill, which we understand is likely to lead to a further event of default given the obligation in the amended and restated facility agreement to procure by March 31st. So that's the first written anything near a notice in relation to the March the 31st date, but we're now only 13 days in advance of March the 31st. And then he's urged to review obligations under two other clauses. Those are obligations about supply of information. And then what seems to be the real purport of the letter, we request you meet with us and all relevant parties in order we put in place on a consensual basis a comprehensive plan to put the development back on track. And we request it occurs within 5 days. And then there's reservation of rights. No mention of conditions subsequent to that. Then go on to, for your note in the transcript, the E.C. Harris March report is at 12.222. Have a 31st December 2015 completion date expected. As to meetings between Mr. Al-Mahiri and Intermas, he, at page 225, tab 225 of the bundle, but he refuses or declines to meet following the letter of the 18th of March, but looking ahead, 759 in April, letter to Mr. Thursby, the Chief Executive. Bottom of that page of his letter, as a show of good faith, I'm willing to accede to the bank's insistence that I attend a meeting with the bank and the contractor, but only willing to do so on 3 reasonable conditions. The first is that the contractor demonstrates that it's got an unconditional Department of Economic Development license to carry out and complete the project. Refers further to that. And then over the page, secondly, that the bank and DAS must meet prior to the meeting with the contractor so we can agree strategy. And thirdly, confidentiality between banker and customer. Then at the last tab of this bundle, we get really a foretaste of the termination letter that's going to come 3 weeks later, 30th of April 2015. Don't need the first paragraph, which is but then you've requested information on the defaults that currently exist under the agreement, noting your obligations under clause 21.5. At notification, we highlight the following as non-exhaustive examples of current defaults. 5.3, the conditions subsequent, and they refer to the 3 items that I indicated earlier, and clause 22.5a, and that's the development completion at 31st of March. Of course, we're now a month after the 31st of March. These are the clauses now being pointed to.
Yeah.
So that's 30th of April. Then I think does come through. We saw that on the 4th of May, actually, the bank got the email about Intermass having permission to build a labour camp. That wasn't something they sought Mr. Al-Mahiri's or DAS's view in relation to. There's no evidence of that. Then there is at 13.231 in bundle, yes, if we can get to bundle 13. There was a letter from Dubai Municipality. The letter itself in Arabic is at 2773, and there's a translation that came from Intermass at 2772. The view that they gave of the to Intermass was that you're not able to contract for any new projects until you have met the requirements for practice while continuing to work on your projects that are currently underway according to the systems in place. It's right to say that this translation is not agreed. It's actually the only translation in the papers that is not agreed. All the others are. There's an alternative version of it at 2774, which is slightly different. I'm not sure this is material. We'll have to see. But the one at 2774, you can say you are unable to contract on any new projects unless you fulfil the requirements of business practice with the work.
But the difference is a bit too subtle for me.
Yes, it is quite subtle. We'll have to see if it has any relevance, but at least there's only one translation that's not agreed. The bigger point in relation to this is that, of course, we're dealing with a project on the Palm, where Trackies is the enforcement authority, and so this is Dubai Municipality, who have jurisdiction on other areas of Dubai, but not the Palm, giving their view as to what could and couldn't be done, whereas what we've seen is that Trackies were turning down permission for new works that were not already approved. So that's that, and then we get to the demand of the 21st of May, which is in this bundle at tab 257. I'm sorry, 258. 258. no, not that's not 255. 251. 251.
Mm-hmm.
So this is the centre of the issues between the parties, whether the bank were entitled to do this or not. Demand at the bottom of the page, reliant on 3 conditions subsequent. And the failure to procure completion by 31st of March.
Yeah.
So that's... Now, I wasn't proposing to go any further with the chronological documents than that, save to tell you that shortly afterwards, Intermas also terminated the building contract. Evidently, with no funds coming through, then there is a difficulty about payment, and they terminate the issues between us and Intermas being unresolved. So that's an outline, at least, of the story as it appears from the documents and 1 or 2 digressions into the witness evidence. Now can I deal with the issues that arise between the parties as to that?
Well, let's just take stock.
Yes.
How much more are you needing?
To give you an outline of the issues, I would think I probably 5 or 30 minutes.
How much, by way of introduction from the defendants, is needed?
We've got an hour and a half.
An hour and a half. Quite a lot for an opening statement.
We can split that in half because we're splitting it 50-50.
But I understand what you agreed, but as I say, well, it's not terribly surprising that quite a lot of time is expended in drawing my attention to the documents.
Sorry, Your Honour, I mean, we could split our hour and a half between ourselves.
We've got 2, but I see, you've got 2 again, right? All right. I don't quarrel with that. Well, we're pretty pressed for time. The person who suffers the most, apart from me, is the shorthand writer. Now, will you give me an honest answer to this question? If we sat till 6 o'clock, is that too late for you?
That's actually what I was expecting to stay 6 o'clock anyway, so that's fine.
Sorry, I can't quite hear what you're saying.
I was actually expecting 6 o'clock today.
Did you?
That's what I was told.
Oh, nobody let me in on that. Any good? Right, well. How are we going to do this? You're going to have the time limit. Mr. Thomas, you can have till 10 to 5. Okay?
I'm very grateful.
And the defendant's counsel can share the rest of the time. And I'll be leaving the court at 6, even if they're still speaking. Okay.
Right. I'll try and improve on
Right.
10 to 5 if I can. The issues, frankly, are quite short in the end. There's quite a story, but
That
actually
I understand.
the issues are pretty crisp. We essentially say 3 things about I deal first with the allegation of failure to achieve development completion by 31st of March and why we say that's not an event of default. I've really foreshadowed one of them already, that it's not within clause 23.2. It's notable that the event of default here is not a simple long stop date, such as banks often provide for. It's not, we may terminate this facility if the project is not completed by the 31st of March. So not listed as a simple event of default like that. They have to get the event of default by reference to clause 23.2, which provides that, was the other obligation clause that I showed you. So there has to be a breach of that other obligation, the obligation to procure completion. Now that didn't happen. So there's a breach of the obligation, but it's only an event of default if it's capable of remedy and no notice is given 15 days in advance of the date. Now, we say that it was incapable of remedy. Analytically, it's very difficult because before the date, there's no breach, there's no failure to comply, and after it, you can't. So it's very difficult analytically to see how the clause in fact can work. But that may be the problem, but that is the bank's problem, we say, and they've drafted the clause in that way, whereas in fact a very simple clause could have been drafted. And one normally sees, one very often at least sees in agreements such as this, banks protecting themselves with a long stop date in much simpler form. That wasn't done. And in fact, as we pointed out in our skeleton, the defendant admits effectively that there's no failure to comply before and that there can't be afterwards. So we say that the default is not within the clause, not capable of remedy before or after. If it's relevant, then all of the evidence about the date going backwards long in advance of the 31st of March shows the incapability of remedy in that sense as well. There's no notice. The only notice there is, conceivably, is not given 15 days beforehand, and there isn't a notice given to cure the breach within 15 days of the 21st of May. And I think we know, incidentally, I didn't show you it, but it appears that the restatement agreement shown from the documents was drafted by lawyers. So this is not, as it were, a drafting. It is drafting and appears to have that result. I think if one looks at the defendant's skeleton on this, I show you what they say about it. It's on page 15 of their skeleton. And it's effectively acknowledging, rightly, that it's an irremediable non-compliance, but say, well, the clause shouldn't be interpreted narrowly so as to prevent it from being an event of default. The better interpretation is that the requirement for notice only applies where the non-compliance is capable of remedy. But with respect, it really doesn't work because the non-compliance is not capable of remedy. And the clause only applies if it is capable of remedy. So say, well, the requirement for notice should only apply where the non-compliance is capable of remedy. It just shows that the clause is not applying here. And then alternatively, they say that the requirement for notice was complied with by the meeting on the 23rd of February and 14th of March. Well, we saw that the requirement was for notice in writing. And we also saw that the letter dated the 18th of March did not rely on clause 22.5a and require its cure, require its remedy. So there is no notice in our submission. The bank was not within the clause. There are two other arguments as well based on impossibility, and these are arguments based on UAE law. look at our skeleton argument. And if I take you to page 15, we put the case on impossibility in two ways. They're both short points, essentially. So, no right due to impossibility. We refer to Article 129 of the Civil Code and essentials for the making of a contract. I acknowledge that refers to a contract. But B, the subject matter must be something which is possible. Then we read that with, or we ask your Lordship to read that with, the Ministry of Justice commentary on Article 472. And may I show you that? It's most conveniently seen actually in the defendant's authorities because they've got both the articles and the commentary together. So if you look in the defendant's authorities, which is a slim volume of authorities, and Article 472, that's the very last page. I'm sorry, have you not got the defendant?
I don't know. I can't see one, but I'm just wondering what it looks like.
Mine looks like a slim volume.
I've got my own copy of Whelan, but anyway, okay. Thank you.
Well, it is Article 472 in Whelan. This is just a photocopy of Whelan. So now, it's Article 472. At this point, we are not relying on Article 472. We're relying on 129.
Where are you in this? Here we are. I found this last page. Yeah.
So there's Article 472.
Yeah.
The right expires if the obliger proves performance has become impossible because of an extraneous cause. Now, for this point, I don't rely on that article. What I rely on is the commentary. And picking it up at the end of the second line, this article has no application to an obligation that was impossible from the beginning. Because if it was impossible from the beginning, then it would have had no legal existence. The possibility may be actual or legal. So we ask you to read Article 129 with that commentary, and we say that the requirement to procure development completion by the 31st of March 2015 was impossible as at 28 September 2014. That's the beginning, because that's the agreement. I doubt this will explore it a little bit more in evidence briefly, but you've seen the Hill report of the 10th of August, and you've seen the E.C. Harris August report that came out on the 9th of October describing the position. So we say that it was impossible to complete by 31st of March already by the date of the what the parties knew or didn't know about that, whether claimant or defendant had appreciated that, doesn't matter for this first point, we say. It's just the fact of it. Was it impossible or wasn't it? There is an alternative impossibility case, which is that the impossibility was later, and that is a case based on Article 472. And for that, we say, well, the performance became impossible, if not by the 28th of September, then later. And we say it became impossible by reason of an extraneous cause, in other words, something for which we are not responsible. And the way we put that is not relying on the slowness of Intermass, because I can't realistically prove to you in this court that Intermass was the sole cause of the delay. It's fair to say, there are allegations about delays in producing designs and in nominating subcontractors and so on. There's an argument, it's controversial, and you can't resolve it. But there's one point that is different, and that's the license. And we say there is sufficient evidence before you that trackees were refusing permission to carry out unapproved works, and Mr. Al-Mahiri's evidence is of which further works there were to carry out which were not yet approved. He has a list in his statement of those works which were yet to be approved, so it's to be inferred that those also would be turned down. And that shows that the works could not be completed by the 31st of March. They couldn't be completed whilst Intermass were in breach of or had the restriction on their licence. They would have that restriction until they had a labour camp built, and they only, it appears, asked for permission to build that labour camp, or already got permission to build that labour camp in the middle of February 2015. So they were not going to get, I mean, I think it's inferred as a matter of common sense that it would take at least some months to build that labour camp, and so there was no way that they would clean their licence in time to get permission to build the unapproved works. And that, we say, is an extraneous cause that cannot be laid at our door. So that's our reliance on Article 472 and the second of our impossibility cases that supplement the factual argument. The second half of the issues you will have seen as well. If there was, contrary to the above, a right to rely on Clause 22(5)(a) and 23(2) in combination, then we say that the defendant was precluded from relying on that right because it waived its right, or it's prevented by the requirements of good faith, and or it would be an abuse of right to rely on it. So we rely on Articles 135, 246 and 106 of the Civil Code. And you can see that in our skeleton, Article 135, set out in our skeleton.
Where are you?
I'm at page 20 of our skeleton. There's no reference to the date of the 31st of March until the 18th of March letter. And you've seen the documents. Essentially, this runs on. I mean, from at the latest, immediately after the agreement on the 28th of September, we got the Harris report within a few days after it. So it's known at that stage that we're heading for completion after the 31st of March, and the date gets later and later and later. So there's awareness of that the date's not going to be met, and there's no complaint about that. The matter just runs on until the 18th of March. It may be that there's mention orally on the 23rd of March, but certainly no written approaching written notice until the 18th of March. Now, the defendant in its skeleton says that there must be compelling evidence. Look at page 12 of its skeleton, dealing with Article 135. Top of the page it says, the official commentary provides examples which further indicate this provision should only apply where there is a compelling need for a statement to be made in order to correct and objective interpretation that silence was consent. Well, the word compelling, with respect, is a gloss on what is said. The article itself, we saw, just says that if a person remains silent, he shall not be deemed to have made an utterance, but silence in the face of need is tantamount to a statement. So the question is simply whether there's a need, not a compelling need. And the examples they then quote, the examples that are given in the commentary of witnessing an act having legal effect which he could stop by his words. Well, we say that's exactly what is happening here. What is happening is that the date of the 31st of March is plainly not going to be met. That's clear certainly by the autumn of 2014. The facility was kept in place. The debt was allowed.
I think you've slightly lost me. I do apologise. I thought we were dealing with Article 106, but we are now dealing with...
Well, no, sorry, I'm on 135 at first. I'm sorry if I...
My fault.
No, it's
my attention got diverted in your skeleton. We're now what part of your skeleton then?
My skeleton, we are on page 20. My apologies, I perhaps ran together because I introduced...
I thought I was right. We are talking about 135, yes, silence. Now this, well, anyway, I'll read this again. But the silence, what I call the loud silence you're relying on is what?
Conduct from 28th of September right through until the 18th of March 2015.
Well, to the effect that that constitutes an unequivocal representation that they weren't going to foreclose.
That's right. Yeah.
Okay, I just want to understand what was being said.
So they know from the latest, the 9th of October, the latest, the date of the 31st of March is not going to be met. They go on providing funds, allowing DAS's debt to increase with interest running on it without any indication that they're concerned. So that's it. That's a face of need, and all you have to do is look at the circumstances.
Thank you.
That's our case. We're within the words of the commentary. They have an additional point, which is clause 30 of the agreement. And do you recall I showed you clause 30? That's the anti-waiver clause.
Yeah.
Well, we make the point about that, of course, that clause also can be, the effect of that can be waived by conduct. What they have done, in effect, by their conduct from September through to the following March is to affirm the facility. That's really a matter of fact, and that affirmation of the facility, we say, overrides clause 30. 30 might have an evidential effect, it might emphasise the barrier, but conduct of that sort was a plain affirmation of the contract right throughout that period. Now, Articles 246 and Article 106 then take the matter a stage further. I mean, if we say that we could rely on a simple waiver in that way, on that conduct, but if we need to, we could go further and say that this termination was not in good faith. Now here, the awareness or otherwise of the bank that the date was not going to be met before the 28th of September would be relevant, but not determinative. So if we could show that they knew before that, that would increase the weight of their conduct being not in good faith. But even afterwards, we say it still is, because they know at the latest from the 9th of October. But in addition, in relation to good faith, we rely on the lack of motivation from the date of the 31st of March. This, we say, was not a termination because of a failure to finish by the long stop date, because what we can see is that the bank was prepared to go on with the project What they were concerned about was the change of contractor. They didn't want it to go on following a termination of Intermass's contract. But this is a termination relying on a failure to procure development completion by a date. And that does not appear to have been the motivation. We've actually only got to look back and look at the fact that they only start being concerned about that date on the face of it on the 18th of March and only actually terminate 2 months after the date. So the focus is not on the date. It's on whether there's to be a termination of Intermass. And that is not, therefore, being motivated by the real event that they're entitled to rely on. There are Court of Cassation cases in our authorities bundle on Article 246. They, with greatest respect to those authorities, I think do this. They show you, and I wasn't going to turn them up now, I'll deal with them in writing. They show you that the courts do rely on this article and do enforce it or decline to enforce obligations because of parties failing to act in good faith. It's not some mere academic point. But I think it's fair to say that turning up the cases is not going to enlighten you as to application of principle to facts. The case is a restatement of principle and show that it's alive and working. So that's Article 246, if Article 135 is not enough. Article 106, we can take it further still, and for that, and I'm now in our skeleton on
Page 22.
Yes, and I rely on 106.2c. Interests desired are disproportionate to the harm that will be suffered by others.
Okay.
And you saw the value of the completed project. You saw the cover that the bank had of 194%. And I perhaps should have shown you one other document in Bundle 13, which may I show you now. Bundle 13, page 234, in relation to disproportionate harm. It's a document from the 7th of May, tab 234. Often saying that he's heard about the licence, but then he goes on in the third paragraph. He's had feedback from E.C. Harris, no progress on site. Then he deals with the bank's exposure in the second half. Our current exposure is 513 million, including interest, with additional budgeted cost to completion of 230. The total cost to completion will probably increase to 800 million, to which will be added around 150 million in finance costs to the ongoing delay. Property value upon completion based on the latest valuation, which is the one I showed you, 1.28 billion. The action seems to be the best available option. So we point to that and say, well, there was still around 300 million dirhams of equity in this project, potentially for the claimant, if this project was allowed to continue. Cost estimates there, albeit broad brush, but with a large measure of contingency. So the bank was protected. Mr. Al-Mahiri or Das had that prospect of equity, and that was destroyed by the withdrawal of the facility. The project grinding to a halt. So that's taking it a further stage. So the case really is not within the contract, alternatively impossible. But if there was any right, it's waived and or it's not good faith and or process. I should have said that the case is simplified a bit because in relation to the contract, the defendant previously relied on its no requirement for notice point on Article 388, but that seems to have disappeared from the opening. So that's gone. Is that what we understand it? Now, conditions subsequent, this has also simplified thanks to the openings. If you look at the defendant's opening on page 22, and where they deal with the conditions subsequent, and then over the page on 23 at paragraph 4.2 we get the defendant's position, and you'll recall there were three originally relied on. It appears to be common ground the claimant and Intermas did not reach a final agreement on an amended contract following the date of restatement. Also appears common ground the claimant did not provide the defendant with the original the contractor's insurance assignment. So that seems now to be the one point that's relied upon. The point that we were making in our opening, which of course came first, was, well, there wasn't actually an amended contract, and so there can't have been we can't be in breach by not supplying something that just didn't happen, and obviously there couldn't have been an assignment of that either. So the point that's now relied upon, it seems, by the defendant is the one remaining matter, that we did not provide them with the original of the contractor's insurance assignment. That is, to an extent, a fair point. We did not provide them. It's accepted with a document in that form. But what we did provide was that the contractor's all risks insurance was in the name of the bank. And my reference to that, just forgive me. I want to show you that document. Whilst that's being found, I'll just refer you to back to one document that you saw earlier, which was at 11176, which was where we saw Ms. Schocker and Mr. Blott dealing with the provision of conditions subsequent, and we saw that what was happening was that the bank was providing the forms to GAS to supply the conditions subsequent. Now, there was no supply of the particular form of assignment of the contractor's assurance in this case. Now, let me take you to the document where they are named as the insurer, and that's back in volume 9. And it's at tab 138.
Yeah.
I should say it's at 138. I give a warning that my 138 has been put into 139, so it may be that.
What should it look like?
It starts with an email from Jean Sebastian.
Yeah, I have that 138. Yeah.
Yes. Then, if you go over 2 pages.
Yeah.
At 1930.2, you can actually see the contractor's all risks insurance.
Yeah, thank you.
And what there is an endorsement on the 11th of May attaching to and forming part of the policy in the name of Messrs. National Bank of Abu Dhabi and or DAS and or
Okay.
So they're named. They haven't got an assignment as such, but they've got something as good as an assignment. They're named and they can claim on it. And they didn't complain about that. They didn't send through a draft document being an assignment of the construction assignment. So the one matter that they appear to rely upon now, we say, actually, we met the requirement in substance. And we add on to that, if necessary, that it would not be acting in good faith and or that it would be causing disproportionate harm now to rely on this condition subsequent. That's condition subsequent. That leaves material adverse change. And this was the matter that came in with the amended defence. And if we look to see what the defendant has said in relation to this, they deal with it at on page 16 is where they start in relation to this. And I think the substance of what they say starts at page 18. Timing. They say we're wrong to say that at no time prior to the amended defence has the defendant asserted material adverse effect, and they refer to the defence. They make, in a sense, a fair point that the defence does make that reference, but what the defence did not do was rely upon material adverse effect as an event of default that entitled them to terminate the facility. We do say that failure to rely on the material adverse effect at the time, and you've seen the clause, that is clear evidence that the bank was not within the clause at the time. No evidence that they were within the clause. The equity that would have been available one of the factors in relation to that. So we say it's too late to start alleging material adverse change more than a year after the event, and that, given the terms of the clause, shows that they were not within it at the time. We set out some more detailed reasoning as to how they haven't shown that they were in the clause. Again, if necessary, we rely on waiver and or good faith, or lack of good faith and or disproportionate harm in relation to this as well. We say we don't need to, we just don't get within the clause, but if by some process of reasoning they could bring themselves within the clause, we say that it was correctly waived, or if it did not good faith or disproportionate harm. Well, that's an outline of the submissions and the issues between the parties. I hope sufficiently introduces them from the claimant's point of view. 5 minutes ahead of the revised schedule.
Thank you. Yes. Do people want a 5-minute break, or we have to do? Come on. Well, it's really not a few. Would you like 5 minutes?
It's going to be till 6, yes, please.
Okay.
All rise.